Um, how do we challenge court jurisdiction arraignments for misdemeanor charges? Says Wolf to Tenawa.
Okay, so with a misdemeanor charge, you have to look at whether or not it's infamous first off, right? So I said in the introduction there, what is an infamous crime? An infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary. It's not the amount of time you get sentenced to, but the amount of time you can be sentenced to, which creates the infamous nature. Therefore, it's not the crime that drives the infamous nature. It's actually the duration in which you can be punished. Okay, so misdemeanors, unfortunately, are not infamous crimes. So if it's only up to a year, then that would not be infamous. There's other ways that we can address it, but Title 18, subsection 555 says that information can only be used for non-infamous crimes, for misdemeanors. So the law does permit information to be the accusing mechanism for that, but the problem is that, and this gets into something a little bit different, but so 98% of all convictions here in America come by way of plea bargain, right? That's 98% of all criminal defendants that don't even get to tell their side of the story, and that is an egregious failure of the justice system, okay? Truth will always lie somewhere between two stories. But when you suppress or prevent one side from telling theirs because you've chosen to accept someone else's side of the story, and as a result, you've taken a side against another individual, then what happens is that when you charge by way of information, then they use that information as a mechanism to be able to create pressure, right? Pressure against you. And through that pressure, they use duress, coercion, intimidation, threats in order to get you to plead guilty. Now, plea bargains aren't constitutional. They are absolutely unconstitutional. They're one of the things that we're going to be getting addressed here in the coming weeks here. But plea bargains aren't constitutional. Article 3, Section 2 clearly states that the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. Nowhere in that does it say anything about adjudicating a crime in any manner other than a trial by jury. So when a prosecutor comes up to you and says, or through a defense attorney, because remember, witness intimidation tampering is not direct intimidation, it is also indirect. So when a prosecutor goes to your defense attorney and says, oh, tell your client that if they don't plead guilty, I'm going to send them to prison for 2 years, right? Or if you don't tell your client that if they don't plead guilty, I'm going to give them this heavy fine, or I'm going to take their children away. Each one of these things is a threat, right? And a threat is the establishment of the contract through illegal means. It's an act of extortion. Now, where the constitutional mechanism comes into play for this particular offense is the Fifth Amendment's self-incrimination clause. Because the self-incrimination clause says no person shall be compelled in any criminal case to act as a witness against himself. So compelled in this context means to bring about through the use of threats or intimidation. So when government uses threats or intimidation in order to get you to act as a witness against yourself, they have clearly, simply violated the Fifth Amendment self-incrimination clause. Well, the problem is that in a plea bargain, down at the bottom of that plea bargain, it says I did certain things and you sign it, which means that you are acting as a witness against yourself. And the way that they get you to do it is through the use of threats or intimidation. That means that it doesn't matter because the Constitution states that no person shall be compelled in any criminal case. So it's not just infamous crimes. It's also misdemeanors. So if you have been threatened or intimidated into pleading guilty, then guess what? That would be an unconstitutional act because the state has used threats, intimidation, coercion, or duress in order to formulate that contract. And we all know that duress is a justifiable defense for a crime of breach of contract or a tort. You cannot use duress to formulate a contract without formulating an unconstitutional, illegal, unlawful contract. So that's the first thing, right? So the contract itself is fully breachable because it's not valid because the way in which that contract was formed is illegal. Therefore, the contract formed is then illegal. It becomes non-binding on parties involved in dispute. But again, going back to what I said before, that any time that there's an unlawful act that's committed in the pursuance of an outcome, that outcome has got to be unlawful, right? Because you can never break the law in order to enforce the law. So when the crime of extortion is committed in order to secure that contract by that criminal act, nothing is valid at all, nothing. And so, when we look at the crime, the threat itself, who gets to decide whether or not you've been threatened or intimidated, right? Well, it's not the judge that gets to make that determination. You are the one. And the reason why is because Intimidation is an inward manifestation. It's not an outward manifestation. So the judge can't say, well, show me your intimidation, like it's a scratch in my arm, right? So you get to make that decision. You decide if you've been threatened or intimidated, you know that, and only you can know that. Nobody can tell you that you weren't threatened or intimidated, right? It's not up to anyone else to make that decision. It's up to you because it's an inward manifestation, not an outward manifestation. So the moment that they use threats or intimidation in order to get you to plead guilty, that would be unconstitutional. It would be illegal. One second. So now another thing that we need to consider here is, and I got to play this one out just a little bit, okay? So when a judge says to you, because most people would say, yeah, well, the judge asked me if I've been intimidated. I said, no, I haven't been intimidated. Well, that's not binding. And let me explain to you the reason why, okay? So the state is made up of a body of men, the whole body of men. And that body of men that makes up the state includes prosecutors, it includes judges, it includes attorneys and law enforcement. All of those agents make up the body of men that is the state, okay? So pretend that my body is the state of Washington, okay? My hand is the prosecutor and my shoulder is the judge. If my hand comes up to you and threatens you and tells you to plead guilty or else, and then my shoulder asks you if you've been threatened, look, my shoulder represents the very same body doing the threatening as the one asking you if you've been threatened, which makes the plea non-enforceable. If the state wanted to enforce a plea bargain by asking you if you've been threatened or intimidated, they would have to bring someone in from outside the body of men that makes up the state. Otherwise, the very same body of men that do the threatening cannot be the same body of men doing the asking whether or not you've been threatened. That would make that plea unenforceable because if one part of the state of Washington threatens you, all parts of the state of Washington threaten you. So if you did plead guilty, you are still in a non-binding agreement because that judge had no authority to be able to ask you if you've been threatened because he represents the very same body doing the threatening as asking you whether or not you've been threatened.
I am the storm.